Good morning. The judgment which I am going to share with you would be helpful for the advocates who appears and for victims of road accident, filing claim application MACTOP, and also those who wanted to be a standing counsel for insurance company, because not that accident had taken place, rash and negligent driving, having license or not, still lot more particulars is required to be understood by the councils, because you can attribute negligence even if the driver is having license to drive, but he may not have endorsement of training for specialized vehicle in motor vehicle license. Heavy vehicle license is totally different, motor vehicle license is totally different. So to deal with hazardous and dangerous material transportations, the driver must have a training, and that training completion should be made engrossed or endorsed on his driving license. This resulted the owner of the vehicle against whom MACTOP passed, insurance company was directed to pay the amount and recover from the owner of the vehicle. They rushed to the Supreme Court. AR 2025 Supreme Court 2324. AR 2025 Supreme Court 2324. Chata Service Station versus Lal Mati Devi and others. Here he did not have a license, endorsed license about his training. But when they have lost the cases, they seems to have, during pending appeal, they attempted to file certificate stating that he underwent the training. But High Court did not accept it for these reasons, that when he gave evidence, he accepted that he did not aware that he underwent the training and there was an endorsement on his license. So an attempt to file it before the appellate court seems to be somewhat a bad attempt. So you can go through these provisions, facts of the cases. The section 14 says that the driver must have a transport vehicle carrying goods of dangerous and hazardous nature to 1 year and required a 1-day refresher course in the prescribed syllabus for its renewal. Section 11 says addition to driving license, which requires any addition to an existing license to drive any class or so to be procured by making an application for the same to any licensing authority. That means he should have seal over his license. These things are banned there so clearly, and they have also says section 10 of the Vehicle Act, Motor Vehicle Act, enumerates the various classes of vehicle for which license is granted, and goods vehicle simply cited those designed to carry dangerous and hazardous goods fall within the class of transport vehicle. So all these things should you, and also section 41 dealing with how these vehicles are being registered. So unless and until you go through the entire provisions of the act, you can attribute more negligence simply that they have a license. If any driver says I have a license, so that is not sufficient. If you are contesting for insurance, then you can very well say that this driver is not having endorsement to training about his training. All these things are must you go through the judgment. I understand AR 2025 Supreme Court 2324 must be Chata Service Station versus Lalmati Devi case. Keep it on file, go through the judgment, and then go through the Motor Vehicle Act also, the relevant provisions referred in the judgment. Best wishes.